Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying watching this legal content, please remember to subscribe. It helps the channel grow. For today's case, we are dealing with the so-called pink tax. If you're not familiar with this term, it is an idea that has been spread by some feminists that goods made for women cost more than goods made for men, and this is sex discrimination and bad. And someone decided to actually make a federal case out of it, and now we're going to decide from appeal how well that's going. So this is the case of Karen Schultz versus Unilever. In this case, Karen, her name is Karen, literally, it's Karen, is suing Unilever, the maker of various deodorants, because they make deodorants, and some of them are marketed for men, and some for women, and they're different prices. So in this case, the Eighth Circuit Court of Appeals has to determine whether this is illegal sex discrimination. Let's get started with this. Karen Schultz sent numerous complaints for violating Missouri's Merchandise Practices Act through their marketing of men's and women's antiperspirants. She's after the deodorant, people. That is the crime here, deodorant. The district court dismissed. Having jurisdiction, this court affirms. So, no, Karen, I'm sorry about the antiperspirants and all, but no. Schultz argues that Conoco, which does business as Unilever, which is a lot easier to say, discriminates based on gender in its pricing of two different Dove lines. One line is Men Plus Care, primarily marketed to men. It is in the name. The other is Advanced Care, marketed to women, though more subtly. The antiperspirants in each line have similar, but not identical, ingredients. Each line has distinct scents. Advanced Care has at least 15 feminine scents, while Man Plus Care has about 5 masculine scents. The women get more choices, incidentally. The Man Plus Care brand comes in a 2.7 ounce size, while the Advanced Care is only 2.6 ounces. The two lines have distinct packaging and labeling. Schultz purchased an Advanced Care antiperspirant stick from each of 6 defendant retailers. She also, by the way, sued CVS, Target, Walmart, and just everyone else. She's just a wonderful person, by the way. She alleges that their price was higher than the comparable Men Plus Care stick, from about 40 cents more expensive to $1 more expensive. Schultz filed a class action lawsuit, so going for broke here, alleging that Dove manufacturers and sellers were discriminating against women in their pricing, the so-called pink tax. I wonder if her complaint literally used the words pink tax, and if I had to guess, I'd say it does. She alleges this violates Missouri law. The district court dismisses. We review de novo a grant of motion dismissed for failure to state a claim under 12b-6, accepting as true all factual allegations in the light most favorable to the non-moving party. However, we need not accept as true plaintiff's conclusory allegations or legal conclusions. A complaint must contain sufficient factual matters to accept it as true to state relief that is plausible on its face. Schultz argues that Missouri law bans gender discrimination in its pricing. So here's what Missouri law apparently has to say on the issue. The act, use, or employment by any person of any deception, fraud, false pretense, false promise, misrepresentation, unfair practice, or the concealment, suppression, or omission of any material fact in connection with the sale or advertisement of any merchandise and trade is illegal. So one wonders right away, how does Dove fall into any of these categories? What deception? Their products are very clearly labeled. What false pretense? They are what they purport to be, the ingredients and everything. What misrepresentation? What have they concealed or suppressed? Nothing. It's a product. It's there. It's on the shelf. Has a price tag. It is in fact deodorant, antiperspirant. It is. So I don't even begin to know how they violated this, but who cares about details, right? A Missouri regulation interprets unfair practice as any practice that either offends any public policy, has been established by the Constitution, statutes, or common law, or by the Federal Trade Commission or its interpretive decisions, which, fair enough. So we will adopt in our law anything the FTC said, which we didn't have to do, but we will. Or unethical, oppressive, or unscrupulous acts, which I don't even know what that is. To establish a claim under Missouri law, a plaintiff must show that she is leased or purchased a product or service from a defendant, primarily for personal, family, or household purposes, and suffered an ascertainable loss of money or property as a result of an act declared unlawful. The terms of the statute are unrestricted, all-encompassing, and exceedingly broad. Consumers need not have a direct contractual relationship to maintain a suit under the Missouri law against a party with connection to merchandise before the buyer enters into a transaction. It's enough that they saw it and wanted to buy it and they were being discriminated against. So they have enough cause of action in that. They don't actually have to go and buy it to develop a cause of action. The purpose of merchandising practices is to supplement defendants' use of common law fraud in an attempt to preserve fundamentally honest, fair play, and right dealings in public transactions. Yeah, fair enough. There is a general dealing of fair dealing. You have to have fair dealing in business, and what would help a lot with that is you have a product and it's well designed and has a clear label and has a list of ingredients, which are the ingredients, and it says what it does on the label, and it's accurate, and it's on a shelf, and the price is the price they're going to charge you, right? It's honest, fair, right? All those things. So what's the problem, Karen? I don't know. Let's read on. Schultz stresses Missouri cases suggest that whether a practice is unfair can be a factual issue, which, of course, this does not override the plausible pleading standard. Just because there is some fact that could be unfair practice doesn't mean you just get to say unfair practice. What is your fact? The law leaves to the court in each particular instance the determination of whether fair dealing has been violated. When there's no evidence of a course of conduct that would amount to fraud or deception, the Missouri complaint can be dismissed. No fraud, no deception. It is a Dove antiperspirant. It is what it purports to be. No fraud, no. Schultz mistakes gender-based marketing for gender discrimination. She ignores that the different scents, packaging, and labels make the products potentially attractive to different consumers with different preferences. So she says, oh, these products are different, and the court says, yeah, they're marketing based on gender, but that's not discrimination on gender. They have 15 cents for women and 5 cents for men, either because men don't care or women care more, and the products are designed differently to appeal to them differently. So, yeah. Schultz argues at length that Missouri law bans gender discrimination in pricing based on a plain language analysis. The Missouri regulation, public policy, and FTC guidance, assuming that Missouri law bans gender discrimination pricing, which incidentally, they're not saying it does, but we'll assume it for the moment. She cannot plausibly allege it using only a retail price difference without plausibly alleging the only difference between the products is the gender of the purchaser. Because it wouldn't necessarily be gender-based discrimination now, would it? If the only difference is the gender of the purchaser, which somehow Unilever knows for sure in advance, then yeah, but no. Schultz also conflates marketing targeted women with enforced point of sale by gender. Women are not required to purchase advanced care products, nor are men required to purchase Men Plus Care products. Both have an equal opportunity to buy. So, yeah, if you think the men's product is better because it's cheaper, there is literally nothing stopping you from buying the men's product. It's right there on the shelf right next to the women's product. Dove is not trying to restrict your purchase decisions. They would be equally happy with you purchasing any of their products, I would assume. So, and CVS and Walmart and Target are not trying to restrict you. They will, in fact, let women buy the Men's Plus Care deodorant. And they will, in fact, let the men buy the Advanced Care deodorant. Yeah. As Schultz puts it, men and women are able to purchase a product marketed to the opposite sex. Yes, they are. Ironically, her claims assumes all men and all women must purchase products marketed to their gender, in her words, due to social conditioning and societal expectations regarding what is feminine and masculine. So the social conditioning goes deep, deep. Men must buy men products and women must buy female products because of social conditioning. No one could possibly make a different decision. Okay. All right. If Schultz's primary concern is price, she is free to purchase the Men Plus Care antiperspirant. Her choice not to do so illustrates a difference in demand based on product preferences, not the purchaser's gender. As Schultz says in her brief, she prefers the scents in Advanced Care line because she does not want to smell like a man. She just does not want to pay extra for her preference. Burn, burn, burn to the ground, burn to the ground. Yeah, why aren't you buying the men product? Because I don't want to smell like a man. But I thought you said that you had to buy the female product because of female conditioning, right? You don't have a choice. So you're not buying it because of the smell. You're buying it because you're a woman and those are female products and you can't buy the men product. But now you're saying it's because of smell. Yeah, and you have a preference and you like the female products and you don't want to pay for it. It's your choice. It is a free market in every sense of the word. You are in fact free. There is no law that makes you buy the female product or the male product. I've checked. There's nothing preventing you from liking men's scents or liking female scents. I've checked. And if you have a preference of one over the other, that's a free decision. So you don't want to pay for your free decision? Well, no. Because preference-based pricing is not necessarily an unfair practice, the Missouri Act does not prohibit defendant's pricing here. Thus, that brings us to the end of the case of Karen versus Unilever. In this case, Karen says, there's a pink tax. Women's deodorants are more expensive than men's. And women have to buy female products because societal conditioning. And the court says, no, you can buy the men's product. It's right there. It's fine. You can buy it. Unilever's fine with it. They're quite happy to sell it to you. And she's like, but I don't like the scent though. And the court's like, well, okay, you don't have to like the scent. You don't have to buy the scent. But you can't just say, oh, it's because sexism when it's because of your preference. Maybe Unilever tried harder with female products to make them smell better because women care. And so there's more expense in that. I don't know. Maybe the ingredients are different for women. I don't know. But in any case, you can make the decision. So it's up to you. So they tell her to go away. The pink tax will have to wait for another day. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.